All right, and back to our Israeli story. We have the Director General of the Department of International Relations and Cooperation, Mr. Zane Dangor. Zane, a very warm greetings to you. Welcome. Israel has accused South Africa of being complicit to the alleged atrocities that are committed by Hamas on the 7th of October. What is South Africa's reaction to this?
Look, our reaction is simple, that we have lodged a complaint with the ICJ in terms of the Genocide Convention. We are using the Article 9, which is a contentious procedure in terms of the convention. It means that we have a dispute with the State of Israel on whether they are complying with the duties under the convention. The Article 1 of the Convention very clearly states that all parties to the Convention have a duty to prevent or punish the crime of genocide. Based on what we have seen and the available evidence that has emerged in Gaza over the last month, that Israel has indeed, in our view and in the view of many, contravening the articles of the Convention, are indeed perpetrating the crime of genocide. So that is why we will be appearing in court at the ICJ on the 11th of this month, where we will be presenting our case as to why we think, based on all the evidence, including the special intent, the crime of genocide turns on intent, and we have found that based on many of the statements from leaders that the special intent is available. I'm not going to comment on what Israel is saying. I think what the media statements just indicates that we do have a conflict, we do have a dispute, and this is what the court will decide on whether the merits of the dispute, whether South Africa is correct in our assertions, or whether Israel is correct in theirs. So, in terms of the unfortunate labels of blood libel, we would strongly oppose those assertions in court, but we will be focusing on the evidence available in terms of the various crimes that we feel, in terms of the convention, that has been breached by the State of Israel.
If you can elaborate further on that, Zane, I mean, we understand that clearly South Africa will have to present a strong case, and you've just referred to it now. What are you going to base your case on, particularly in terms of the evidence submitted, sir?
So the evidence is something that, we will ventilate in court in detail. You saw the mass deaths. You see the over 20,000 people killed, most of them civilians. Of those civilians killed, the vast majority are children, women, and other non-combatants. We see that these crimes are committed with intent. We see we see a systemic approach to the attacks in Gaza. Remember that the crime of genocide does not require millions of people to be killed. What it requires is a demonstration that there's an intent to destroy a group of people in whole or in part. And we've seen while we've done this, is we looked at the nature in which these crimes are unfolding. We looked at evidence that is emerging from various sources, including the special rapporteurs of the Human Rights Council. So all of them have looked, there's a grouping of these special rapporteurs on it. In our papers are on the website of the ICJ, where we cite the various sources that allege that a crime of genocide is being committed. So we will be presenting the evidence or the facts, but the main issue that we will be looking at is intent. I need to emphasize this. Genocide turns on intent, and we've seen the statements of intent accompanied by action by the various leaders and actors within civil society, within the State of Israel. Remember, even if it's journalists or other political commentators who make these genocidal statements, state parties to the convention have a duty to punish those who are making or inciting genocide. So part of what we are arguing is also that incitement to genocide is happening, and that the government of Israel is not responding to that in line with their duties under the convention.
Absolutely. And Doctor, as we know, I mean, Israel have strongly disputed that accusation, particularly around the word genocide, and saying that they have been abiding with the international war laws. But are there any other countries that have indicated that they will also be supporting your move?
The nature of the convention is many countries want to join, but this is a dispute between states. So we, as a state party to the convention, and Israel as a state party to the convention, both Israel and South Africa do not have any reservations on any of the articles on the genocide convention. So it's in terms of that we are taking this forward. Other countries will most likely be joining as amicus. Only states can join in as amicus. They will join in most likely after the provisional measures hearings that are taking place. Remember that the hearing on the 10th and the 11th is dealing with provisional measures, because this case will be long and drawn out. But we are asking that while the substantive issues are being dealt with, that we hold Israel to account to end the issues that we allege are genocidal. That includes calling for an immediate ceasefire. And this is a binding, if the court rules in our favor, this will be binding. It's binding on all state parties to the convention. So, it's a very important hearing on the 11th and the 12th. So, we anticipate that after the provisional measures hearing, that other state parties will join. But we're already seeing, for example, Malaysia, Qatar, and others writing letters of support or statements of support to the actions that are being done by South Africa.
And Doctor, you have also requested the International Criminal Court to also intervene. The court deals with individuals. Who do you think must be held before the ICC?
Look, the International Criminal Court, as you pointed out, it differs from the ICJ. The ICJ deals with state disputes and holds states accountable. The ICC holds individuals accountable. Important principles within the ICC is that it holds those most responsible accountable. It's called command responsibility or superior responsibility, which means that since the Second World War, it's no longer just good enough to hold the soldiers, the foot soldiers, accountable. What the ICC does in terms of its jurisprudence is hold those who give the orders to account, and those who also prevent soldiers from breaching international laws, including crimes against humanity, war crimes, and also the crime of genocide. So we feel that all those who are responsible, most responsible in terms of command responsibility and superior responsibility, must be held accountable. This could include, for example, the head of state, the heads of the military, and also senior politicians.
All right. And Doctor, I mean, we've just been hearing that as the ICJ might be the UN's highest decision-making court, but most of its judgment are often ignored. So what do you hope to achieve with this submission as well as application? So
there's two approaches to the ICJ. We get ICJ approaches that goes through what we call Article 8, which is through the United Nations. These are generally advisory in nature. So, advisory, we feel that these judgments, even though they're advisory, should be respected by all countries who have a serious respect for international law. But we felt that we're going to go for Article 9, which provides for binding measures if the court so decides. So it'll be very difficult for any country that says they respect international law to ignore a binding, finding or order by the court. And that is why we went for this approach rather than going through an Article 8 approach, which is through the United Nations.
Doctor, thank you so much for your contribution there. That was the Director General of the Department of International Relations and Cooperation, or DIRCO, Dr. Zane Dangor.